Bismillahirrahmanirrahim. Today we would like to talk about the case Brown versus Westminster Bank, which had been hearing in year 1960. By this opportunity, I would like to expand about the issue towards customers. The issue is pay check with forged signature. The plaintiff, Mrs. Emma Eliza Brown, has claimed that signature was forged on her check by Mrs. Beatrice Carls, her husband Albert Carls, and her daughter Joyce Carls, and represent for payment to the defendant. This was again defendant, which is Westminster Bank, for £12,347 of 329 check to allegedly to being wrongly debit to her account by the defendants.
I will continue about the liabilities of a paying bank. The bank was denier of the liabilities, in which emitted 100 checks in February 1959 and after April 1961 were forged. The bank was denier of the liability because the bank already queried the authenticity of signature on a number of checks, but it was assured by the plaintiff that the signature was hers. Besides that, the branch manager of the bank also had visited the plaintiff in many times, and on each occasion he asked the plaintiff to check her statement of account, and together with all the paid check relating to the debit in the statement. The plaintiff did not inform the defendants that any check were forged. In this case, the customer should inform the bank immediately of any false alterations of the check.
Okay, now I will explain for the protection of collecting bank. According to the case, the plaintiff made a claim against dependent bank for £12,347 toward 329 check wrongly debited to her account at bank. The bank was denied the claim as the bank admit that 100 check were forged, but the plaintiff failed to prove that the remaining check, which 299 check, were forged too. Therefore, the health contended that plaintiff was stopped from denying the amount were rightly debited to her account. Estoppel is a legal principle that prevents someone from arguing something or asserting a right that contradicts what they previously said. This situation related with the types of estoppel, which is estoppel by debt, which means it is a situation where rules of evidence prevent a litigant from denying the truth of what was said or done. The plaintiff claim was failed as she did not check the statement carefully before agreeing for the payment, and also she cannot make a claim from a bank because the manager have told her about the suspicious to the account, but she just ignored him and proceed the payment. She also cannot blame the bank as they only do their job as told by the customer. All of these matters cause her claim cannot be approved as it is her own fault.
At the end, court held by Roskilde Jail was divided for three. Firstly, on 5 October 1916, branch manager bank mentioned that Carl's check where plaintiff told branch manager all Carl's check were genuine, and plaintiff never denied the genuineness for those checks. Secondly, plaintiff had failed to prove that none of 229 check was not signed by her, and had failed to prove that more than 100 check was forged. Thirdly, in this case was an estoppel in favor of bank where plaintiff representation to the branch manager. With that, on 5 October 1916, forged check were denied. The bank had acted as its detriment in paying check, and with her silent plaintiff claim failed.